Please take your seats. Thank you. Welcome. Excellency, ladies and gentlemen, dear guests, welcome to the Humanitarium. Welcome for those who attend this conference here physically in our room. Also, welcome to those who follow this conference online. It's a pleasure to have you here for this conference on changing the narrative on international humanitarian law. We are also very pleased to have the participants to the 12th Advanced IHL course, which is taking place this week in the same room. So I'm sorry for you, you're staying in this room. But we have a group of professors coming from all over the world to discuss international humanitarian law issues. And we're very happy to have you in this room and have many colleagues who are interested in this topic. A few years ago, we started a cycle of conferences, events, debates on generating respect for the law. We did that because we felt an immense frustration. And I need to start with that. We still feel frustrated seeing so many crimes being committed in conflict areas. And the ICRC, other organizations work hard to alleviate the sufferings of victims. But of course, we would like to prevent them in the first place. And we are so frustrated because we have so many tools today and so much knowledge to prevent these violations, to improve the training of armed forces. And somehow we listen to a discourse which is very toxic, people not believing in the law anymore because of fear or because of a climate of radicalization. So after a series of events and conferences, we thought that we have to do something about it, start somewhere. And we started a project to change the narrative and started looking at the glass half full and counter this discourse of pessimism on solidarity, on empathy, on the strength of the law, and started a project with academia to collect success stories, instances where the law has been respected. So that's what we want to talk about this evening. And present this project and also stimulate a conversation with you and the audience online on how to counter the toxic discourse. So we will have presentations, but we are also inviting you to send your questions and comments. And we have prepared an hashtag, IHL in action. So you can connect to Twitter, for those who use Twitter, and send us your questions using the hashtag. So during the course of this event, people in the room or online use the hashtag IHL in action and send us questions, comments that we will then try to address and ask our panelists to answer or debate. So this event is in two parts. First, we will discuss the project with Julian Garcia from the ICRC, working on research. He has been working for the ICRC for several years in Geneva, in the field, in Colombia. And she has been working for the past 2 years with 4 IHL clinics, which are represented here this evening. Leiden, with Professor Robert Heinz, will be presenting about the project. So after Julian, he will be telling you about the project. But he's also representing Laurie Blank and her students at Emory Law School in the US, Yael Wirsman from Herzliya in Israel, and Giulio Bartolini from Roma 3. So they've worked several years with the students of their law clinics to produce the cases you'll see. Then the second part of this evening, we will discuss about how the law matters actually and how it can make a difference. And for this, we have 3 different perspectives. So we are very honored to have the Ambassador Londono Soto with us, a permanent representative of Colombia. You will find more information about the bios of our speakers on the leaflet you got, so I won't give a long introduction. And we have also Mike Schmidt with us, who is very famous in the IHL circles for all the work he does. Professor Mike Schmidt is at the US Naval War College, and he has been always working on the issue of how to operationalize IHL in the US military training and instruction. And finally, we will have the Director of Law and Policy here at the ICRC, Dr. Helen Durham, will give the ICRC perspective. So thanks a lot. It promises to be a very interesting evening. Thanks for being so many to attend this evening, where we will talk about good news, while not forgetting what's happening, all the violations and crimes. So it's not about being naive, but it's about also trying to change the perception. And I also invite you after the conference to visit the exhibition of objects we brought back from Iraq, real objects from cities at war. And I think it's important also to have this in mind, but to also showcase the successes, to also share the best practices, and to show actually that there are many instances where the law is actually respected, but we need to share that and tell them and tell the parties to conflicts how to do it. So that's the sense of this event this evening. Thank you very much. Julian, the floor is yours.
Good evening, everyone, and thank you for being so numerous in the room. Before I present you the great project called IHL in Action, we have a small and quick promotional video, so I'll let you have a look at the video and I'll come back to the project later. Thank you. Okay, so this is the database. So the project conducted by 4 IHL clinic was about gathering a collection of instances of respect for IHL, what we like to call IHL success stories, with the objective to demonstrate that IHL does work and there are daily evidence of compliance with IHL, and we wanted to gather them in a database so that everyone can have a look and use examples in their daily work, in speeches, in statements, in teaching sessions, to change the way we usually look at IHL through the lens of violations, but instead working on how it actually works. So it's a navigable database through a map, so it's clickable on countries. It's also, the cases are also searchable through topics. And the cases are under the form of case studies with a summary of the case at stake. All the cases are based on publicly available information, press releases, NGO reports, statements, only sources that can be found publicly. And also the interesting aspect lies at the end of the cases in a discussion section under the form of questions. So I can imagine that students working on how does law protect in war will be quite familiar with the format. And the idea was also to invite readers to reflect upon the facts that are presented. So we assume that there are instances of respect, but let's reflect on that. Why are there positive application of IHL? Can we discuss what happened in the case? And there's also a section on elements contributing to respect for IHL. So what may, from legal and non-legal arguments, what may have conducted to an actual positive application of IHL? So this database is not about statistics. It's not an exhaustive review of all compliant behavior. This is not possible to have, and it's not the objective. And something important to say that it's not about minimizing the massive violations that are sadly still occurring every day, and it's not about legitimizing the behavior of any belligerents, but it's really to invite to a change of perspective on how we teach, how we talk, how we research on IHL, and to change the lens and encourage to this change of lens. You will see that it's quite humble at the moment, the number of cases, and Professor Heinz will explain later the challenges, because it's actually proved challenging to collect example of compliance. Somehow the burden of proof is even higher than for violation, since example of compliance rarely make the news as violation do. So we start with a few cases, as you will see, and we call for more. So obviously the law clinics will keep on going with searching for cases, but we also invite you and everyone, states, belligerents, to work for enriching this database and at some point be able to share and promote best practices on IHL. So now it's online officially from now on, so I will invite all of you to have a look at this wonderful project, and please feel free. You have this nice feedback button on the top hand corner, so feel free to submit your own example that you may have, and to work to promote and share those best practices on IHL. So I will pass the floor to Professor Heinz to develop a bit more on the genesis of this project. Thank you very much.
So, welcome and thanks for inviting us for this presentation. I think I had a small PowerPoint prepared. Is that possible to? That's from my colleague, Mike. I'm happy to talk about that as well, but I think this is better. Yeah, thanks a lot for coming to this event, which makes us very proud. And I say us because I'm speaking today in order to present the process which has led to this website and the current results of finding positive examples of IHL compliance. But it's in the end a team of 4 IHL clinics. And Vincent already mentioned that. This includes Laurie Blank from Emory Law School, Jael Vias-Gwirsman from IDC Herzliya, and Giulio Bartolini from Roma Tre University. And why am I stressing that so much? Because although Julian just mentioned this is just a humble start of showing you the first examples of respect for IHL in practice, this would have never been able to achieve without this close cooperation between the 4 IHL clinics. And therefore, I actually would like to start to present a bit to you this cooperation, this which from my side is also a success story of IHL. Yeah, it's the bringing together 4 IHL clinics from all over the world, very different backgrounds, I think is also a first step of showing IHL has a lot of energy to offer to also young students. So how did it all start? In the end, we had, I was told, and that's exactly what Mike was expecting, that this, okay, it works. So what happened was that 3 years ago, actually Mike was the reason that we brought these clinics together. He doesn't really know about this because he was missing in the afternoon when I started telling the story. But Mike Schmidt invited Laurie Blank and myself to the West Point Military Academy to discuss questions of the Ukraine conflict. And at that time, Laurie and I had a lot of time to talk about our 2 IHL clinics. And actually, we used all the coffee breaks and lunches to talk about this. And we realized, wow, we had the same idea. We interpreted this in a different way. Our clinics work in a different environment. But it would be great maybe to work together. And 1 month later, Laurie went to Israel and met Jael, and they had the same experience. And then we thought, wow, now we are 3, we have to do something positive here. And 1.5 years later, Giulio joined this group. And this is important because this actually was able to enabled us to start this project with the ICRC, because at the beginning we decided we wanted to just maybe have like a yearly exchange between the clinics, but then soon we got the idea, okay, it would be great to have a common project, and all of us had already cooperations and contacts with the ICRC, and we contacted them and said, so we would like to do something together, do you see an opportunity? And the Law and Policy Forum said, yeah, well, we have some couple of ideas. They gave us, I think, 2 or 3 choices. And one of the choices was finding positive examples for the respect of IHL. And I think every one of us thought that's actually something completely new, because 2 of us, or 3 of us had worked even in the international criminal tribunals in The Hague. We always thought about violations of IHL, war crimes, etc. And this fresh approach on looking at IHL also to show that people are constantly complying with IHL, we thought that would be great. And having those 4 clinics together would give us a very big pool of opportunities, because we all have different students from different backgrounds, very international, also very important, with a very broad skill set, including different languages. So we decided, okay, this would be a great project. And so this doesn't work without meetings, which I hope I can show you. I'm not sure, not really. So what we did was, first we brought this new generation of IHL lawyers, as we call it, together in different occasions. So 2 years ago we met in Tel Aviv, 1 year ago in The Hague and Leiden, and this year we're going to Atlanta and Washington. It's important because these students, when they're doing their research, they also need to obviously exchange their views on how they proceed, how they conduct their research, and also exchange their views on what is actually compliance and what is not compliance. I come to that in a moment when I talk about the challenges, but being clear what compliance is probably equally difficult from a legal and factual perspective than finding what violations are, because you can say, okay, this according to this view, this is complied with IHL. Another view would say this is not complied with IHL. So what we wanted to do with the research project, and you see here some important point. First of all, that's our background. We are academics. We offer this IHL clinic to do something which is not so popular everywhere in the world, but is getting more and more thrust now, offering students the possibility to apply their theoretical knowledge to a practically relevant topic. And what our task was, given by the Law and Policy Forum of the ICRC, was to collect real-life practices where rules of IHL were respected and adequately implemented. And the idea behind that, the objective to do that on the long run, was to counter arguments about the erosion of IHL by providing real-life situations of respect. I think everyone who has worked in the field or as an academic, as a teacher, knows this moment when you talk to someone who is maybe not all the time involved in IHL, or even an IHL person says nowadays everything is going down the drain, everyone is violating IHL. And we wanted to counter that and find other examples. And the idea was already to have these results to be integrated in the ICRC's dissemination and prevention activities. So what was the methodology? It was, of course, a desk research which we conducted, namely that students would use the 4 different locations, Italy, Netherlands, US, and Israel, from their point, from their university, and start doing 2 things, factual research and legal research. Because obviously the students needed to find incidents where they would think, okay, this complies with IHL, actions by government forces, non-state actors, or other actors on the field, and then also find out, is this really complying with IHL? They were using open public sources. Everything you can find online nowadays was obviously a first step, but also legislation, media and NGO reports, and blogs, but also social media like Twitter. Actually, in the end, me being over 40, this is a world where I'm also learning every day something. The students at one point told me that they really, one of the first steps they're doing is looking at Facebook and Twitter tweets in order to find out where is something happening. Because news reports are sometimes not giving all the information. NGO reports very often are focusing on violations, so looking into social media can help a lot. What also was very important was interviews with ICRC field staff and other experts in the way that the students, of course, spent always a considerable time into looking into these situations. So to give you a background, we started this whole process with making a list of 49 conflict situations. We said recent conflict situations, but we, I think, went back up to 25 years to the 1990s. And then we divided these conflicts among those 4 IHL clinics. At the same time, we set up a list with different categories concerning the IHL areas we wanted to look at. And Julian also showed this. These are now the 4 categories we have on our website. After the students had done their desk research, a lot of them tried to get in contact, also with the help of the ICRC, with people who have worked in that area, in that situation, because that obviously helped in order to support certain research they had done and observations they had done, and could find and they could get new tips or new advice in order to find additional incidents of compliance with IHL. Also, there were interviews with NGOs and colleagues. Actually, one of my colleagues, Hector Ola Solo from Colombia, who is teaching there, he came to The Hague and we interviewed him also. IHL topics, so here you see 5. In the end, we boiled them down to 4 in the end. Conduct of hostilities, detention, humanitarian relief and assistance, implementation of IHL, and occupation. As you will see from the examples, so there are at the moment 27 cases online, you will see that there are not so many with regards to the conduct of hostilities. There's much more on detention, humanitarian relief and assistance, implementation and also training of IHL. That has something to do with the fact of how easy or difficult it was to get the respective information. Because obviously conduct of hostilities examples would require to get sometimes confidential information which we couldn't access at that point. That's, however, one of the things we want to do in the future. So over those 18 months, we started, I think, in January last year, in 2016, we looked at 45 different situations, usually 1 month per situation, per clinic. So then you can multiply that by the different clinics involved. What were the challenges? So that's actually, I think, what was supposed to be the topic of my presentation. Of course, there's always something like this. We had a time plan in our idea, in our mind. There was, of course, always limited time for research, also because we had a bit the ambition to cover a number of conflicts, also because we wanted to cover as many geographical areas and diverse conflicts. We didn't want to focus only on 1 or 2 and then coming up with the criticism that we are not being too balanced in order to find the respect for IHL. And then, yeah, something, all of us, we had done clinic projects before, and a lot of them also on violations. From my personal experience, it was the first time that after, I think, 3 or 4 weeks, the students came back to me and my supervisors and said, we almost didn't find anything. So the normal way of finding research, finding examples of compliance was very difficult, and they really had to go maybe 1 or 2 layers deeper in order to find the first incidents. There are problems with regard to soft facts and hard facts. One challenge was the cross-referencing of sources. In the end, we had to approach this similar to something to a prosecutor who is looking for violations of IHL. Our colleagues from the ICRC asked us not to only rely on one source, but if ever possible to look at a second and a third source to support this. There was a problem with regard to real versus partial compliance in a way that some people, sometimes you had a specific situation, maybe limited for a time, the release of child soldiers, and you will see this is now also one good example is on the current website, on the current database. But then if like half a year later maybe child soldiers were used again, is that now still a compliance, yes or no? These were judgment calls we had to do. Respect of the template, there you could see that, of course, this was a project in development. We were 4 different clinics working on this. We needed to always, every 6 months, because some of us worked in semesters, had to update the students on how they would fit their results of their research into the template provided by the ICRC, which in the end led now to this final version, which we find on the online platform. Language barriers. yeah, we had the advantage of having dozens of students. I don't know, probably over the 1.5 years, we probably had something like 40 or 50 students involved in this research. Otherwise, we would have not been able to accumulate so much information. Nevertheless, and a lot of them had different language skills. Nevertheless, sometimes you have conflicts where the language just is unknown to any one of the researchers. And that, of course, then we had to rely on secondary sources, etc. Results of the project. So we have analyzed 45 conflicts. We actually came out with hundreds of pages of respect in the end. I think at one point the ICRC was almost overwhelmed with all the information we sent to Geneva, and they still had to go through this. We found examples of respect as well from states as armed groups and non-state actors. And as you have now seen, the publication of the first round of results by the ICRC, you can now find on this website. I think it may be also good to memorize that for the future of everyone who is interested in that. And the result, yeah, although it was difficult to find that information, we can say IHL is respected, and I would even say on a daily basis. Finding these success stories, however, is not as easy because we just maybe are not used to looking into this. And also from regarding the problem that IHL very often has prohibitions. So that means if I'm not torturing a prisoner of war, that obviously is compliance with IHL, but nobody is going to report on that. So these are things which played into the whole 1.5 years of research. But in the end, we now have this website. Okay, we have already seen that. I included that in my PowerPoint nevertheless. And my conclusion is reality as to the compliance with IHL is more nuanced than what some people say nowadays. Examples of compliance we can find in different areas. Conduct of hostilities, the treatment in detention, protection and care, humanitarian relief and assistance, training and dissemination. Sometimes, even though a situation might point towards violations of IHL, this does not mean that the situation does not include instances of compliance. So we very often found both things at the same time, parallel to each other. At the same time, this does not mean that the whole situation has to be considered always positively. Yeah? So we also wanted to be careful with that and not saying, okay, this means this side of the conflict, this party of the conflict is always doing things well or not. And what is important, the last thing, maybe we need to keep in mind that we should apply the equally high burden of examples of proof with regard to the respect then for the violations of IHL. So similar to maybe something we are doing in the context of finding individual criminal responsibility. So this was just a brief overview. Thank you a lot for your attention. Thanks also to the ICRC with entrusting us with that project. It was a great pleasure to engage in that. And we are very much looking forward in continuing this in the future and looking forward also to any kind of stimulations or ideas which are coming from outside. So thanks a lot. And here you find, if you want to hear more about the clinics, our websites and contact details. Thanks a lot.
Thank you, Robert. We could feel the passion and all the hard work. I think we need to thank all the students who are not here, but many students participated in this project, and thank the work of the 4 law clinics. I think it's very interesting to see, indeed, that we can come with some conclusions, nuanced conclusions, that we have some cases. Not as many as we want, but we are coming soon with more cases. So it's the beginning of something, so we're very happy to launch it. Now I'm turning to Ambassador Londono Soto. There were not many good news in recent years when it came to conflict, but Colombia, finally, after decades of conflicts, could manage to bring this process to fruition, the peace process to fruition. We know it has been a long journey, and there are still obstacles along the way. But among all the bad news, we hear about this good news this year. And we also know that in the conflict in Colombia, unfortunately, IHL did matter. And I think in that conflict, IHL played a very special role and was very much discussed. So we'd like to hear from your perspective on this success of peace, but also how IHL played a role during these years of conflict. Thank you.
I see so many people that are young. It gives me hope. It really, really moves me. And the reason is not just because I think that you are interested in the theoretical approach of IHL or what can be done in terms of improving practices. It's because you are really sensitive to suffering, the suffering of millions of people around the world. And that really makes a difference. Coming here and accepting the invitation by ICRC is not just something formal for me. It's not just because of my role as ambassador of Colombia before the UN. It's because we have gone through difficult times. We have still many, many challenges ahead of us, but we are convinced that respecting IHL has been a key issue for our process, of the peace process that we are trying to implement. It's going to be a long journey. We are just beginning. But IHL is not a matter of the past. It is still present because the suffering of the people is there. The sequela of conflict is not something that is over. It's not something from the past. The objective of this talk is to discuss key elements to change the narrative of application of IHL. Of course, the critical question is that IHL mainly applies in times of war, when all the underlying tensions within a society come to surface and manifest in a violent and destructive way. And that's why I'm grateful, because we can share today, my colleagues from Colombia, who are here also, our own experience. Francisco de Goya, the great painter from Spain, wrote in one of his master's works, "The sleep of reason produces monsters." My presentation intends to show that even in the middle of the nightmare of war, the light of reason shall endure. The body of law that today we call IHL has been historically developed in post-conflict situations, the morning after the war's horrors, based on the idea that unnecessary suffering and pain can be avoided, and that in the middle of devastation, there are rules to be respected. In Colombia, we coexisted for more than 50 years with the tragedy of an internal conflict. I was born in a generation that does not remember a country in peace, and now is determined to open this possibility. However, I must clarify that in a protracted conflict like ours, the dream of peace has been constant. During these 50 years, we have had several peace processes in which we have reached the disarmament of different armed groups. I would like to stress the role that IHL has played in the construction of peace. I hope this can be our contribution to this change of narrative of IHL. It's useful in war, but we cannot and shall not forget that IHL is also essential to build the basic conditions for peace. The hypothesis is the following. IHL is the shared language of the parties to the conflict, and as such, is an essential vehicle to open the channels that in the long term can give the possibility for a dialogue. Of course, IHL does not address the structural causes of conflict, and it was not designed to do it. but it certainly allows at least common denominator for the parties in conflict. Indeed, the role of the ICRC is critical in this respect. Its neutrality and impartiality guarantees the possibility to talk with all the parties and advancing the dissemination and appropriation of rules of IHL by the actors in the field. I would like now to stick to the chronology of our recent events. The first act took place in June 2011, when President Santos, our president, national president, sanctioned the Victims' Law. This is a critical piece for building the peace, mainly for two reasons. The first one, the state actually recognized the existence of an internal conflict that, after many years, this question was highly controversial, and many people even deny it. Secondly, this recognition was directly linked to the recognition and reparation of the victims. Article 3 of this law defines victims in terms of people who suffer infractions of IHL or grave violations of their human rights in the context of the armed conflict. As the Constitutional Court established in its study of this provision, the definition of conflict given in the Victims' Law is not restrictive but comprehensive, and it aims at measures conceived for a context of transitional justice and post-conflict. A year later, in August 2012, President Santos announced to the country after a round of exploratory dialogues with FARC, both parties had agreed an agenda of negotiation with 6 points: rural reform, political participation, end of the conflict, solution to the problem of illegal drugs, victims, and implementation and verification of the agreements. A table of direct negotiations in La Habana was launched. With patience, discretion, and numerous consultations, each point of the agenda was negotiated. Without surprise, the final stage of the process was one of the most difficult for all of us. It dealt with the laying down of weapons and the definite cessation of hostilities. It was the core of the end of the conflict itself. A set of urgent measures of humanitarian nature were agreed in order to create trust in the process. Signing and implementation of a protocol for the mobilization of child soldiers by the FARC, joint humanitarian demining in specific areas, search for disappeared persons. In all of these measures, the support of ICRC again was essential, and is still essential. On the other hand, FARC and the government wanted to shield the final agreement to find a judicial protection for what had been agreed. What kind of figure could help to shield this essential document? In the middle of this sensitive discussion, a light was opened through a very particular use until that point of IHL. As we all know, Common Article 3 is the basic and minimal set of rules for a non-international armed conflict. According to this article, the parties to the conflict should further endeavor to bring into force, by means of special agreements, all of part of the other provisions of the present convention. This is a provision of an international treaty, universally ratified, addressed not only to states, but also to non-state armed actors. Clearly, a very useful and peculiarity of IHL when it comes to an agreement to be signed between parties to a non-international armed conflict. Suddenly, journalists, editorialists, and many people, academics, and many others in Colombia were flooded with questions referring to the possibility of finally signing the peace agreement as a special agreement under Common Article 3. IHL was then publicly associated to the peace process. It was like the key issue. The questions are extremely interesting and should be analyzed in a wider perspective, taking into account other peace processes. In a special agreement under Common Article 3, as an international treaty, Can a non-state armed group sign a treaty? Are the non-state armed groups subjects of international law and under which conditions? Of course, I will not try to answer these complex questions. I'm not myself an expert on IHL. However, there were three main advantages when considering the peace agreement as a special agreement. The first one was the Geneva Conventions and additional protocols establish obligations to non-state actors. Second, these humanitarian obligations are minima of any special agreement. And third, its signature engages the parties to comply with humanitarian international obligations. Many detractors of this figure focus their argument on one point. The special agreements are of humanitarian character and designed for times of war. They cannot be used for matters related to peace or political participation, rural reform, or others that were included in the final agreement. This was, of course, a restricted interpretation of Common Article 3. However, the ICRC gave an alternative interpretation, and it was extremely helpful, taking into account its recent commentary on the first Geneva Convention, since the purpose of the provision is to encourage parties to an armed conflict to agree on a broader set of rules to protect persons who do not participate or who no longer take part in hostilities. Special agreements providing for the application of international humanitarian law may be considered as special agreements under Common Article 3. This interpretation was the understanding between the states and FARC. What really matters is that the provisions that are put in place between the parties serve to protect the victims of the armed conflict and alleviate their suffering, mainly civilians. Additionally, the ICRC reiterated that as long as peace agreements contain provisions derived from humanitarian law, or if they implement humanitarian law obligations already incumbent upon the parties, such agreements may constitute special agreements under Common Article 3. The Constitutional Court of Colombia added that at the international level, Article 3, common to the four Geneva Conventions of 1949, which empower the President to conclude humanitarian agreements with armed groups in arms, is part of the constitutionality block of our country. Here we have a very strong example of the way in which evolution of IHL proves to be useful not only to rule conflicts, but also to rule their ending. The final agreement for the termination of the conflict and the construction of a stable and lasting peace was signed in November 2016. As a special agreement under the terms of Article 3 common to the Geneva Conventions of 1949 for the purposes of its international validity. This is a literal quotation from the preamble of our peace agreement. Accordingly, the final agreement includes specific provisions derived from treaty and customary IHL. I will mention the most important ones. Chapter 3 of the agreement is dedicated to the end of the conflict, which deepens and strengthens the program established during the negotiation process concerning the reintegration and restitution of the rights of children that left the ranks of the FARC. The support of IOM and ICRC has been essential in this process. Chapter 5 of our peace agreement, dedicated to victims, provides the creation of a comprehensive system of truth, justice, reparation, and non-repetition, which contributes to the fight against impunity by combining judicial mechanisms that allow for the investigation and punishment of serious violations of human rights and serious violations of IHL. This system is composed, among others, of the Special Unit for Search of Disappeared Persons in the context of the armed conflict, which is an institution of humanitarian and extrajudiciary nature. The information received or produced by this unit cannot be used for the purpose of attributing responsibilities in judicial proceedings or as probative value. The ICRC has been and will continue to be a key partner in this endeavor. Chapter 5 creates the Special Jurisdiction for Peace, consisting of a series of courtrooms. Today, we have the first courtroom just today, including an amnesty chamber and a chamber for peace to administer justice and to investigate, clarify, prosecute, and punish serious human rights violations and serious violations of to IHL. The main principle and cornerstone of this special jurisdiction is that crimes against humanity, genocide, and war crimes, that is, any violation of IHL, shall not be the object of amnesty or pardon or equivalent benefits. Finally, another measure derived from obligations of IHL was the sanction in December of amnesty law aimed at detained members of FARC who have carried out their operations in accordance with the laws and customs of war. I do not have the time, and this is been already long, to get into the details of these provisions and the way they are being implemented. But I just wanted to underline that, as you can see, the component of IHL is at the core of the final agreement and created the trust and confidence that was necessary by both parties. Once the final agreement was signed, more than 7,000 members of the FARC and 2,000 of their militias moved to the demobilization and transitional zones in 26 points of our national geography, where they proceeded to lay down their weapons, and now they are in the moment of the middle of the process reintegration. The United Nations Monitoring and Verification Mission established by the Security Council, 2 resolutions have been one 2261 of January 2016 and Resolution 2366 of July 27 have led the process to neutralization of weapons. More than 9,000 weapons, 1.7 million of ammunition, 38 tons of explosives, 11,000 grenades, 4,000 mortars, ammunition, and dismantling more than 700 caches. These common efforts are just a reflection of the state, the FARC, and the international community working together that have made possible the fact that now weapons are silent and confrontations with the FARC ended. The military hospitals in Colombia have almost entirely ceased to receive wounded soldiers, and compared to the historical average of the last 30 years, this peace process has saved about 2,700 lives. This number is much higher when compared to the periods of the recrudescence of our conflict. I want to be clear about something to finish, that this is not the end of the process. It's just the beginning. It's just the beginning. As I said at the outset of my presentation, of a long collective task of reconciliation. The challenges ahead are huge, but we, as a country, have a unique opportunity to turn out history on our side. In Colombia, we learned through hard times that IHL is not the end in itself. It's rather a very powerful instrument that we must consistently, persistently use to always underline and capital letters put the human person under the protection of the principles of humanity. Thank you.
Well, Your Excellency, thank you very much. I think it's an IHL success story again that you're giving us, and so I think we are learning a lot from that, and I saw many colleagues in the room learning from your presentation, and they had not realized maybe how much IHL played a role also in bringing peace. So I think definitely this is what we are looking for. We have a few cases there, but we are looking for opportunities to speak about these successes, and I think that's what we want to create with this platform. So thanks a lot for this testimony. Thank you very much. Now I'd like to give the floor to Mike. Mike, please. A different perspective on the impact of the law on how military operations are conducted. And Mike is known for his contribution to IHL through his papers, through his articles, through his teaching. But I think also what we wanted to highlight is how IHL can play a direct role, and plays actually a direct role, in the calculation that the military have to make when they target, when they make this difficult decisions. So Mike, the floor is yours.
Thanks, Vincent. You've just heard a presentation on IHL in action at the strategic level. So what I would like to do is take it down to the tactical level, not about what countries do, but what you do, a good practice that you engage in with regard to a particular attack, a single attack. I should say at the outset that I work for the United States government, but I am not here in my official capacity. I think you're monitoring Twitter. If @RealDonaldTrump tweets, I want you to give me a little signal, okay? So, we're going to talk about something that a lot of folks talk about but don't really understand. It's called the collateral damage estimation methodology. I have to tell you, it's extraordinarily complex. I sent 2 of my guys off and they spent an entire week learning how to do this process. Our standard briefing at the War College on this process lasts over an hour. I've got about 10 minutes, so bear with me as I fly through this and try to explain what we do in the collateral damage estimate methodology. Now, CDEM is the acronym for them. CDEM is a way, is a process by which we bring empirical data into a process in order to estimate civilian casualties, the number of civilian casualties, and try to figure out how we can mitigate those civilian casualties. In other words, how we draw the number of civilian casualties down. This is usually misunderstood as the proportionality calculation made by American commanders. By the way, this is now used by NATO, Australia, and other countries. That's not what it's about. It's not about proportionality. Indeed, if I had to tie it to any particular IHL norm, I would tie it to the precautions in attack norm. Because as you see, we'll try to refine the process to avoid civilian casualties as we go along. At the end of the process, it's called CDE Level 5. I'll explain what that means in a moment. The commander makes the proportionality call. This process does not make the call for the commander. The commander must still make that proportionality call before he or she authorizes the attack. It's used for deliberate targeting. In other words, it's a pre-planned target. I know that I'm going to attack that particular target. I'm going to put that target into the system and see what's generated. This is not a process used for time-sensitive targeting, what we call dynamic targeting, where you have a jet in the air, for example, waiting to get a call to come in on a particular target. Mentally, the commander that authorizes it and the Air Operations Center, for example, they will go through this process mentally. But this process that I'm going to be talking about tonight is for a deliberate target. You know you're going to strike that target usually within 48 hours. And finally, it provides a casualty estimate with respect to individuals. It does not provide an estimate of damage to objects. This does not mean that we ignore damage to objects. But damage to objects is factored in by the commander after getting the collateral estimate with regard to the number of civilians. Now, the process begins with weaponeering. I used to say many years ago, now I say many decades ago, I was a weaponeer before I went to law school. Weaponeering is where you get a target, a particular building made with particular materials, et cetera, particular size, and you try to figure out what's the best weapon to use against that target. Given the characteristics of the weapon, is it day, night, what's the weather like, et cetera, et cetera, et cetera. Okay? So in the CD process, before it even is initiated, the weaponeer will look at the target, pick a weapon for you, and then you initiate the process. But you need to make sure that you've got geospatial orientation of the target, that you know where the target is, because I'm going to explain in a moment that distances matter. So you need to know where the target is. You need to have positively identified the target. That's called PID, positive identification. You need to ensure you've complied with the law of war. In Switzerland, that's called IHL, for those of you who don't know. And finally, if you're going to strike a target and the target risks causing severe environmental damage, or CBRN, chemical, biological, radiological, or nuclear hazards, then you will eventually get to collateral damage estimate level number 5. Again, I'll explain what 5 is. It's the critical level. So let's begin. Let's assume we believe we're in compliance with the law of war. We know where the target is. It's not going to cause chemical a release into the atmosphere, so we're ready to begin the process. Oops. So here we are. To your left is what is called a collateral concern. This is something we're worried about. This is a civilian building, for example. We are going to strike this target. What you do is you set up a collateral effects radius, and then you draw a circle or a box around the target. What you're trying to determine is if there are any collateral concerns within this box, determined by the collateral effects radius. Now, how do you know what that radius is? How do you know how long that line is? That is a classified distance that estimates the widest destructive area of the biggest weapon we have, that the commander has. The biggest weapon we have, it's a big area, okay? But the one that the commander has. So you take the biggest weapon and you say, if I've dropped the biggest thing I've got, again, it's a classified distance, is there anything inside that, any collateral concern inside that area? If the answer is no, then your CDE, your collateral damage estimation assessment, is called CDE1, CDE level 1, CDE1 low. Low means you're not going to strike, you don't believe you're going to strike any collateral concerns, okay? Then if this is the case, then the appropriate commander, unit commander, can authorize the strike, but we have to be a little bit careful here because typically there are restrictions on particular weapons and munitions. You may not use, for example, cluster munitions because you're in a coalition and coalition partners are a party to the treaty. Okay, but if I can make this work, but here we have a collateral concern, it's CC2. You see it's within the CDE1 circular effects radius, or collateral effects radius, okay? So now, because of this, we must continue to the next level, CDE level 2. Now, the first, CDE level 1, considered all weapons. Now remember, the weaponeer's already picked the weapon. So now you look at the weapon the weaponeer's picked and you say, okay, what class of weapon has the weaponeer picked? In this example, the class of weapon is a PGM. That means precision-guided munition. So it's more accurate. So you bring in your radius, and it's at CDE2. And so now you've solved your problem because the collateral concern lies outside the CER, the collateral effects radius. So now the commander can go ahead and authorize the operation subject to any restrictions. This would be called a CDE2 low because your collateral concerns fall outside. A PGM is being used, a precision-guided munition. I've put unitary in there, meaning that it's a precision-guided missile with one munition on the system, a precision-guided munition with one explosive instead of a cluster weapon, which would be analyzed differently. But if you still have a collateral concern with level 2, what do? Well, by now you should know the answer. You go to level 3. There we go. So we've considered weapons generally, then we considered the class of weapons, PGM, and we can't get that collateral concern out. Now you consider the specific weapon, the individual weapon. Our weaponeer, who we started the process with, has picked a Mark 82 with a PGM kit. A Mark 82 is a dumb bomb, okay, a gravity bomb, 500-pound gravity bomb, and there's a kit that fits on the back of the bomb that gives it guidance, okay? That's the one that the weaponeer, but there are a lot of these because they're relatively cheap, I'll tell you. So in this particular case, this is the weapon that's picked. The first thing you do is you have, remember your weapons effect range. What you're doing is looking for the weapons effect range of a PGM with a guidance, or rather a Mark 82 with a guidance system. In this case, because you're using that particular PGM, now your collateral concern is no longer a concern because it falls outside. This is called unmitigated weapons effect range, and the reason is you're just looking at the bomb itself, not the way you drop it, but the bomb itself. If that's the case, you're good to go using a PGM with a Mark 82, but what if the collateral concern doesn't fall outside that unmitigated area? In this case, the team will try to mitigate the harm to civilians, and they will look at various tactics that are used in order to do that. So I've got a couple on the left, mitigation tactics. One is a delayed fuse. In other words, you fuse the weapon so it penetrates the building and explodes inside the building. The target building, that building will absorb much of the blast, which will mitigate the harm that might be caused to nearby structures. Or you adjust the angle of attack. Here, in this one, an angle of attack of south to north would endanger this building. Because bombs, because they're on an airplane, bombs tend to come off, and something about physics go that way. They don't go east-west. So in this particular case, this is dangerous. So what you might do to mitigate is you might go west-east, because if your bomb misses, it will land what is called long. It will go long, but there's nothing in the area where long would put at risk. So you mitigate. In this particular case, we've used a delayed fuse to absorb the blast, thereby mitigating the risk to our collateral concern. Now, what if that doesn't work? If that doesn't work, you continue to level 4. And this is where it gets fairly complicated. Not more complicated than this clicker. Okay. Okay? Would you like a glass of water? We have water up here, darling. No, okay. All right, now we're at CDE level 4. What you're going to do here is you're going to very much refine your assessment. You're going to look at the buildings that are placed at risk. And you're going to ask, what are those buildings made of? Because different materials react different ways with blast. So you're going to focus on building type of the collateral concern. I'm trying to get back one slide. Okay, that would be 2. That's going the wrong way. There we go. In this particular case, the collateral concern is a multi-story building made of concrete. It's masonry. And such buildings are very strong. So when you factor in the fact that the multi-story building is made of masonry, now you fall outside the area where you have to be concerned about it, okay? But if that was a single-story adobe building, which will collapse with almost nothing, in that case, you still have a problem because you run the risk of civilian casualties, so you go to your final level, level 5. Okay. With level 5, you now know there will be collateral damage. There are likely to be civilian casualties. Your purpose now, since you were unable to mitigate, your purpose now is to figure out how many civilian casualties. And the reason you need to figure out how many is because your approval authority to conduct the strike is limited by what is known as the NCV, the non-combatant value. So a commander, sometimes as high as the president, will say, you have a non-combatant value of, let's say, 5, okay? If you're going to conduct a strike and you do the CDE analysis and your figure is 6, you lack the authority to do that strike without going to a much higher level in order to get authorization to conduct the strike. It exceeds your NCV. Sometimes this could be very low. In Libya, in Operation Unified Protector, the NCV was 0. In Afghanistan, for many operations, the NCV is 0. You cannot conduct the strike if you go through the CD analysis and believe that there will be harm to a civilian. So let's see how level 5 works. It's focused on density tables. In this particular case, you look at what the use of the buildings is. We looked a moment ago at what it's made of. Now we're looking at what does that do. So a single-family urban building may have fewer people than a warehouse if you have warehouse workers. And you take into consideration things like day or night. There were likely to be very few warehouse workers at night. There are likely to be many during the day when the warehouse is in operation. You look at episodic events. Like, is it a day where there are religious services? Is it market day would be another example. Now, all these figures have been pre-calculated for your area of responsibility, known as the AOR, the area where your operations are being conducted. Sometimes the figures are calculated for individual countries, so there are analysts looking around the world where there may be conflict and doing population density studies, doing pattern of life analysis to determine when, for example, bridges are likely to be crossed and when they're unlikely to be crossed and so forth. That's all available on computer and it's plugged in here in CDE level 5. And remember, what you're trying to get is how many people will be hurt. Wow, then he went 2. Okay. So only one person will be hurt when I throw this because this is not a cluster clicker, it's a unitary clicker. Everyone understand that? The ICRC leadership is saying, can't we buy a clicker? You know, I'm thinking I contribute every year to the ICRC, spend a little bit of Schmidt's money on a clicker so when he comes back, how hard is that? At any rate, take note. At any rate, in the last slide, what we looked at was population density based upon the use of the particular collateral concern. Is it a home? Is it a shopping center? Is it a hospital? Is it a school? You look at the population density. Now it becomes more complicated because when a bomb strikes, the destructive force dissipates over distance. And so you have to take that into consideration. So in this particular case, well, the slide changed. And now it's changing involuntarily. Can you guys control slides back there? In the back. Can you please go back 2 slides? Stop. 1 slide forward. Stop. I'm just going to signal you. I'm going to put this here. All right. Okay. No one was hurt. There were no collateral concerns. All right. So CDE 5, another thing you do in CDE 5 is you look at how far from the target, it's called the aim point, the point where your weapons, how far out are your collateral concerns? And we divide the area in half, the blast area. So within the what's called inner annulus, okay, in the inner annulus, each civilian counts 1. Remember, we did population densities and so forth. But once you move half the distance out, each civilian counts a factor that is classified based on a pattern of life analysis. So let's say just hypothetically, it was 10 in the outer annulus, 5 in the inner annulus. That would be 5 plus 1/2 of 5. Your civilian casualty estimate would be 10. But that figure varies depending upon where you're at. If you're in the outer annulus and you're in open areas, everyone counts 1 because they will be harmed. Okay? They're not in a building. Next slide, please. Another thing that's just taken into consideration, and you can see it here, is you ask how much of the facility that the civilians are in is going to be affected. Because in this particular case, part of the building to the left, collateral concern number 2, part of it lies outside the blast area. So you know now that that building will not be affected 100%, and therefore you adjust your figures. And then next slide, please. And you put this all into a computer and you get an estimate. Now, what you are doing is you are getting an estimate of what you believe, after doing all this analysis, will be the number of civilians that will be killed, and you compare that to the non-combatant value. If it's less than the non-combatant value that's been set usually by your national command authorities, highest level, then you may proceed with the operation. If it's higher, you may not proceed with the operation without going to higher headquarters. You must understand this is not a proportionality determination. It is a determination on whether you've got a green light to make the proportionality determination or whether you must stop. And it gives you a figure that you can put in your head as you're making the proportionality determination, which involves many other factors, like harm to objects, like the nature of the military advantage your operation is going to accrue. Next slide. Okay, this was really quick. We have a YouTube video that you can watch. 2 of my officers, Tim Kelly, Major Tim Kelly, Marine Corps, and Jeff Thurner, who's now Lieutenant Colonel in the Army, put together, I sent them to the course, they put together this video. Just Google collateral damage estimation, Naval War College, you'll find it, it'll be your very first hit. Next slide. This is where I will be next Monday and you won't be. Thank you very much.
Thank you, Mike. You've managed to turn this room into a barracks. It's amazing, it felt like back in the days, So thanks a lot. It's interesting to also notice that in your presentation, you did not refer to any legal articles, but actually you explain how it was working and how IHL plays a role in that, but maybe that the actors doing it have lots of considerations focusing on the civilians, but may not actually refer to legal articles. So that's an interesting...
Well, I will tell you that there's an attorney, a judge advocate present throughout this process. Mm-hmm. In fact, at least for the Americans, there's an attorney present from the moment you identified the target all the way through battle damage assessment, post-strike assessment. So there's always an attorney being a part of this.
So we had an academic perspective, we had a more political perspective on also the peace process, we had this military tactical perspective. I'd like to now turn to the ICRC perspective. But before that, I want to remind you that you can ask your questions using the hashtag IHL in action. We've received a few questions already. So now back to you, Helen, for the ICRC perspective.
Well, thank you very much. It's really a great delight to see how many people are here. The idea that I hear so often that particularly young people are not interested in humanity, there's cynicism. Cynicism is cheap and easy. I see daily in a job that is heartbreaking that actually people today, whether it be experts or particularly young people, they are more keen than ever. And one of the examples, recently we opened up applications for 4 internships in our policy division. We got over 3,000 applications. So that's an evidence-based document, evidence-based piece of information to indicate that anyone who wants to say today young people don't care actually hasn't done their research. But as well as thinking, I thought I'll be quite quick. I will ignore my speech because we've really not got much time, and many know the ICRC's views on this. But just quickly to explain why we started this. We hear many voices today from politicians, religious leaders, the media, humanitarian organisations, academics, talking about the unacceptable breaches of IHL. And I think it's within this context, it's very easy for people to become disillusioned and to think that this framework, this legal regime, is either irrelevant, useless, or doesn't work. It's a very easy conclusion to draw, particularly for those not in this room tonight that are the experts on IHL, but the outside world. And I think those of us who believe in IHL and believe it's something worth advocating for often have to stop and take a sober breath and realise what the debate is about. And one of the first issues, which is very clear, is that the framework of IHL, ironically, has never been stronger than today. Despite this discourse that it's eroding or respect is eroding, we have more treaties, we have more jurisprudence, we have more cases, we have more examples of the implementation into either states or militaries or other groups' command orders. And we have a very high understanding in the public. And in fact, perhaps the understanding in the public brought about by the media talking about IHL, perhaps that has created what I would call what the great Marco Sassoli has called in our discussions today, a credibility gap, where we promise a lot, international law, and what people see is a little deliverance. How do we amend, respond to, or intelligently engage in this potential credibility gap? Another thing I think is really important is that we ourselves, I bet everyone in this room who's been involved in IHL, we often are the ones that are perpetuating a negative discourse. I look at many of the speeches I give across the world, from in the Security Council to media, and it rightly so focuses on the unacceptable nature of breaches. So we thought within the ICRC it's a job to start to turn the narratives, I think there's not one, there's many, around to try and build a confidence in an area that we know works. Now, what we've heard tonight just briefly was we heard obviously Robert talk about the enthusiasm, which I confirmed at the start, and that it can be done, it's difficult. And I want to make a formal apology to all the students that worked, because I know how hard they worked. I know they submitted 700 pages. I know the ICRC only dealt in the end with 40 pages, but we have to in this process walk a balance between our role as the guardians of IHL and our neutral impartial work. So some of the examples we've had to be able to not use for our database, but actually they could probably be used in other circumstances. How do you have an intelligent, sophisticated discussion about when IHL works without offending or deeply being disrespectful for those people who were victims of the same party or group when it didn't work? How can we find the right balance between shifting the narratives but also remaining true and not doing inverse denunciations? If the ICRC doesn't denounce when things are wrong, how can we make sure we do it intelligently when we try and raise the fact that it's useful? And we heard, Your Excellency, I think it was incredibly important to hear from a practical situation, and I really loved the term you used, that IHL, above and beyond the legal framework, provided a common language, a common starting point for people who were enemies to sit down and negotiate. And I think what you were really working towards and discussing was what role does IHL play in looking at how society is after a conflict? So it's not just during the conflict. And then I think, Mike, having you walk us through in a very tactical, very practical, and I know, sorry, very frustrated with the low technical skills of the ICRC, but work us through in a very forensic manner so we can understand IHL in action, not just at the meta level, but actually how it's used. So I think that's very rich for the ICRC. Well, launching the database is exciting tonight, as I mentioned, and having these IHL in action case studies up there, which we believe will be useful to you all, but also to those of us who are talking constantly with different stakeholders And we do urge you to actually get on the database and provide some input. But I think at the end of the day, the reason why ICRC is trying to do this could be synthesized down to two questions. How can we articulate the immediate and long-term benefits of respecting IHL or respecting the law during times of armed conflict? And how can we promote more compelling, non-legal arguments, particularly at a policy level? Now, at the moment, the Law and Policy Department is also working on other areas of research to support us in that area, because I think we have to look at how we can have a narrative or narratives to different stakeholders. The narratives we need to have with those who are involved in conflict, the weapons bearers, is definitely about ownership, and we heard about that today. It's about those who are actually engaged in the fighting having ownership of this area of law. Then when we look at IHL as it pertains to states and policy making, that's where we need to look at having evidence. The evidence for a state to actually understand and raw facts that compliance with IHL has an impact or might have an impact on whether people flee and whether you eventually have migration. What is the evidence-based, I think, is an area we're currently working on with research undertaken in the Law and Policy Department. And then I think going forward, we are very keen to research the issue of IHL and peace building. What is it that IHL contributes post-conflict to make sure society can put itself back together? So there's some research issues that we're looking at. Just for a moment on the roots of restraint, as it's called, and hopefully in the next year you'll be hearing a lot more about this. The early findings of this research project, a project that looks at what is it that influences from a psychological, social, religious range of impacts upon a person, what influences the behaviour of those engaged in armed conflict. And very early findings are very clear to say in certain circumstances that training in IHL has a significant impact on curbing violations. So often we get told, what is this training that the ICRC, that many other organisations do, does it have an impact? Now it has to be qualified, like most good research, that was in one area, but I think the important is it's not just the training, it is who does the training, what is the credibility of the trainer, how is the training done, so there'll be a whole lot of very rich evidence that comes out in that area. I think going forward that there are many, many research questions we in the ICRC would like to engage with you on. I think it's exciting times. We don't want to be, as Vincent said at the start, we don't want to be naive. We, more than any organisation, know the horrors of armed conflict. So this is not a discourse about the fact that the world is a good place. This is a discourse and an engagement about the fact that there is usefulness and relevance in IHL, and we need to start being very clear that this legal framework is not only just part of humanity's common heritage, but something that does have an impact on the lives of thousands and thousands involved in armed conflict. Thank you very much for your attention.
Thank you very much. Now we have little time for questions, but we have questions online and questions from the room. So I'll take one question from the room and then one question from Twitter. So you're first, please. Thank you. We have some, yeah. Giovanna is coming with a microphone.
Thank you. Yes, it works. First of all, I want to congratulate the speakers for their excellent presentations, from the political aspect to the technical, to the work done by the students. So thank you a lot. I just have I have one comment and then one question to Mike.
But maybe you can start by introducing yourself.
Ah, yes, okay, sorry. So my name is Hisham Khadarawi. I'm the Director of Operations for Geneva Call. We are an NGO that is working and promoting IHL respect with armed groups in conflict zones. So I have just one comment. It's interesting because it reminded me a bit of the launch of the platform, and I think it's really timely. What Geneva Call did 5 years ago, it's a database on a collection of humanitarian commitments made by armed groups. So it's basically a baseline of all armed groups' policies, where they could, they have a space where they could put their unilateral declarations, their statements, their internal rules, agreements with states or INGOs, and the deed of commitments that they signed with Geneva Call. It's interesting because we can make a parallel between the declarations that they made and the effect on the ground with this online platform on the actual implementation of these commitments, if there is any parallel or not. Maybe they put thousands of commitments online in our database, and then there is no concrete results. I think it would be interesting with Geneva Call and ICRC to see if there is, I think, room for working here and see there is actually a link. I think another point as well, when us at Geneva Call, we signed deed of commitments with armed groups, they send us their compliance reports. So every year they have to send us their compliance reports where it's registered every step they made in implementing their commitments for a specific IHL provision. And I think here as well, it depends. It could be some good material as well for ICRC continuing in making sure that there's actually improvement on the ground. So yes, I like this parallel between what Professor Yael said this morning, the declarative compliance and the operational compliance. I think there is a lot of interaction between the two. So this is for my comments. And my question to Mike, I appreciated your presentation. I believe it requires a lot of staff and computers and calculus. I'm wondering, when you work in coalitions with other countries, do you share as well the same type of technology with the coalition members, or every coalition member has their own way of calculating the damage evaluation, or you have one and then everyone is following the same system? Thank you very much.
It does work, I promise. There you go. Yeah, try now.
Test.
You can still use your...
It's the people in the back messing with me.
It is.
Payback. The answer to your question is, in a coalition, you will have a combined targeting cell that includes people from other countries. We share our technology with them, our knowledge. We make it releasable to the coalition. What's important, though, is remember, we're not making a proportionality call. The commander will make the proportionality call, but if you're in a coalition, members of the coalition will have what is called a red card. And the red card in football, the proper term is soccer, the red card means you cannot execute that mission because we're a member of the coalition. And the red card, by the way, is played with a degree of frequency.
Thank you very much. So we have had a series of questions from the internet, which revolve around this idea. So I tried to capture several questions at the same time around the idea of self-congratulations. How do we avoid that? How do we avoid the fact that armed forces or governments or armed groups could use the database or this approach to somehow use it for propaganda, for instance? So how do you address this question? Maybe I can turn to you.
Yeah, I think that was one of our major concerns throughout the whole process, which is in the end a strange thing, because we started from the assumption there's so many narratives or news about IHL violations, but once we start with like choosing one or two examples of compliance with IHL, it might turn also into a direction which we don't want, that parties to the conflict say, okay, now we are doing everything right. As you will see, there's on the one hand, there's a disclaimer on the website which says, for every example which we give, it doesn't mean that now everything in that conflict was okay, or it does. So what we don't want to do is by giving a few examples from certain conflicts to make any kind of evaluation into a direction, this one side is better than the other side. That was never the intention. The intention is to show, to give good examples which indicate IHL is respected. As I tried to explain, this nevertheless requires that everyone who is using these examples takes a very educative and educated and sensible approach to these conflict situation and doesn't use one singular event as an evaluation of the whole situation. So of course there's a certain tension in that, or a balance you have to strike. But our hope was by selecting examples and cases from all over the world, from different actors, to show more, not to show more the advantages for IHL or the compliance for IHL, not making specific statements on certain conflicts or certain actors. That was not the idea behind that. It was rather supporting the idea of IHL compliance as such. And as far as I see it at the moment, we are on a good way there. Probably this will be even better once there are more cases and examples, because the broader it covers conflict situations and actors, the less I think it's possible to say, okay, one side is preferred or the other side is neglected, which definitely is not our intention.
Well, thank you. Another question which sounds like coming from the academy, I would assume. It's an interesting question, and I think you can combine it with this question also of how to showcase instances of compliance, but also not diminish the fact that there are crimes and violations. So the question is, why do we think that violations of IHL invalidate the law, while the same isn't true for speed limits or other domestic laws? I don't know, I'm turning to you.
Okay, thank you. I think just very quickly from an ICRC perspective, we are very aware that we don't want this database, this attempt to start a different type of narrative to be instrumentalized. And I'm sure there will be dangers involved in this. We're not naive about it, which is why the submission of a year and a half of work being 700 pages and the ICRC takes 49, it's frustrating. And it's not, please don't get me wrong, the database is not one that you can input into. We would encourage academics, research students, PhD writers to actually do their own journey in this area. We don't own the law, we are a guardian, but it's owned by states and it's about everyone. So I think we have to be very aware, as I said, about the issue of potential instrumentalization. The self-congratulation one, we have to also be aware. But let's be honest, ladies and gentlemen, many, many times as international humanitarian lawyers, successes are achieved, and sometimes we don't take the time to take a breath and say, that was a good thing that happened. I think we are also dedicated to making things better, sometimes for our own energy. It's okay to say, it's great that we've got this new treaty. Isn't that exciting? Or it's great that this military manual was changed. So I think we have to balance the self-congratulations. But I always say whenever I'm talking to young students that you need 3 Ps to be an international humanitarian lawyer. You need passion, you need persistence, and you need patience. And these 3 things fight with each other constantly. To be passionate, it's hard to be patient. So I think we also need to be able to take each step at a time. Of course, it was a wonderful question. I think the international community puts far too much expectations at times onto IHL and international law in general. They understand that the law is still fine. Domestically, if you have a law against breaking and entering a home and that law is breached, probably, sadly, even in Geneva right now, there's probably some sort of crime going on. That doesn't invalidate the domestic law. You don't have people saying, oh, the law's irrelevant, it doesn't work. So I think there's something about the way the international community looks at at the laws of war globally that has higher expectations. The other final thing on that is people are very understanding that the police force, even though they're fighting often in an asymmetrical environment, they're fighting against people who might not follow a police procedure, everyone understands in most societies that having rules and regulations for the way police work is critical to society. So often when we hear that states can't utilize IHL because it's an asymmetrical warfare, I think we have to really look at what is it that conflict is about, particularly from states and even non-state armed group actors which are representing their communities.
Mm-hmm. Thank you very much. And it's true that we have this database, but we have other instruments, databases with other types of practices. It's important here to mention the online casebook, How Does Law Protected War, which is produced with the University of Geneva, with Marco Sassoli, Anne Quintin, Antoine Bouvier, Etienne Custer working on the coordination of this project. So you have also many other cases which are available online. Here we are singling out these cases of respect because we really want to create a positive dynamic. And I think that was very clear in your presentation and very inspirational. There was a question for you is, and I cannot resist, that's coming also from Twitter, will your speech be on the database? So you'll be happy to hear that actually people consider it as an IHL success story and that your speech should be on the database of success stories under Colombia. So I'm afraid we have to stop soon. I just want to give you a chance to say a last word if you feel like concluding this panel.
Well, I mean, thank you very much. I know how to do this.
Okay.
All right. No, I congratulate the ICRC. I will tell you that sometimes it's perceived that folks in the military and the ICRC are at odds. That's not the case at all. The military values the ICRC as an organization which protects them and helps them understand the rules of the game. My final comment is a comment that I made a lot during today's symposium, is the trick to getting states to comply, non-state groups to comply, is you have to be able to explain to them why it is compliance with IHL is in their operational advantage. It's great to tell them it's the morally right thing. It's great to tell them that it's the law. But in fact, compliance with IHL actually advances your operational position. You don't let the enemy operate among the population. The population will not be giving intelligence to your enemy. The population will be giving intelligence to you. You're not wasting resources you could use in other engagements, and on and on and on. So I believe that if you want to sell this to the armed forces, you have to explain to them why it's in their benefit. And having done this for 40 years, it's without a scintilla of doubt, it is in the benefit of virtually all armed forces to comply.
Well, just quickly, and thank you for the working microphone, Mike. I love that your name's Mike. So anyway. Briefly, every single ICRC delegate that goes into the field experiences positive examples of when IHL works. You know, I won't even start on that. Everyone has that experience. Everyone that works at headquarters sees when we shift things. How can we harness this positive energy to continue to make a very loud voice that what we see today in society is unacceptable, but how can we continue to build confidence that what we're doing is worth it in the short term and the long term, and the costs and benefits, well, the costs of not applying IHL and the benefits of applying it is something that we need to get better at articulating. So I hope you all take this opportunity to go on the journey with us.
Thank you. So Robert, and then I'll give the final word to the ambassador.
Yeah, I wanted to mainly say maybe two things as a final statement. First of all, we today talked also a lot about violations earlier in a smaller group, and my point was even when we talk about violations nowadays, we have to take into account that this is very often done against the background of international or national prosecutions of war crimes. The media is interested in that. We said the taxi driver is interested in that. And that's amazing because 25 years ago or 50 years ago, that was not happening. No one was talking about war crimes trials, etc. So even when we talk about violations of IHL, this might be a positive thing because we have a system which is maybe not perfect yet, but it's actually already operable and it's in place. So this is great. And on the other hand, the next step, trying to give positive examples, I think it's a great way to add another component to the history of IHL and how you depict this area of IHL. And I just wanted to thank everyone coming here to listen to that, but also everyone who contributed to this, the ICRC giving us the task, but all the students, you mentioned these students, and we would love to give all their names, and the supervisors and the clinic directors. It was a great team effort, and we are very happy that we were able to achieve this. Thanks.
Your Excellency.
Thank you. When we are facing complex and difficult times, pessimism might prevail. But it's exactly the opposite what we are seeing today. IHL, it brings good news. It decreases the suffering, and compliance with IHL definitely helps people in many places around the world. That's why I want to express and ratify our gratitude to ICRC for the work you do, for the assistance you have provided to many countries like ours, and because for you it's a constant invitation to continue exploring, studying in a very rigorous way, but also with passion. Passion and rigor are two components that really can transform the world. And here you came with a curiosity, interest, skepticism, I don't know, but I am absolutely sure that afterwards you cannot leave Geneva without really considering that you can do something concrete, small steps, but concrete.
Thank you very much. So now I'd like to invite Yael, Giulio, and Laurie to come to the front because they are representing the 3 other IHL clinics. And we have a little gift for you because we don't do it every time, you know.
Wow.
But not always. But this time we felt that a little gift, symbolic gift for this work was needed. I don't know if Yael is
not feeling well.
Okay.
So she's knocked out a little while.
All right, so we'll save this for her. So this is the little gift, and also for you too, our dear guests. So thanks again, and I hope you feel energized and you will explore also possibilities to look at the glass half full. And this is a perfect transition to tell you that there is a cocktail reception up there. So not the glass half empty for a change. And I invite you to join us at this cocktail reception we have at the cafeteria. Just follow our colleagues who will show you the way. Thank you and good evening. Thank you. Thank you. Thank you.